Hello, this is Matt on the Moon Family Sedan channel. Of course, we're all wondering, when will Judge Torres finally rule in the SEC v. Ripple case? When is this damn thing going to come to an end? Now, nobody knows, well, except for perhaps Judge Torres, and any clerks that are working for might have some sort of hint as to that. But I can share with you what might make sense to be looking towards in terms of timing. I have some insight from a few attorneys, actually. And look, there's been so many predictions, and those dates for those predictions for the end date of the SEC v. Ripple case have come and they've gone, and we still haven't seen it. And just to be clear, like I like people just sharing their insight, drawing upon, their experience in legal fields, looking at performance of judges in cases, and then making predictions about the most probable endpoint for a case. I appreciate that, even if that doesn't come to fruition, because what people are doing in considering such things is they're looking at the typical or average behavior of judges in cases and then saying, hey, if they continue to behave as they historically have, here's what you can expect. It's stuff along those lines. And so the fact that those dates come and go, that doesn't bother me in the least. But there's another thing to consider in terms of the timing during the week in which rulings typically have come down, and that's what I want to focus on. So I actually have comments from a few attorneys within this video, and then I've got some stuff from David Schwartz also, pushing back against somebody who's just making up nonsense about the origins of XRP, and that was in response to something from a former SEC attorney who was saying things that I just don't think makes sense. So plenty to break down here, but before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's a brand new article from the CryptoBasic published today and covering the perspective of an XRP community member in terms of the final potential end date, just from this individual's perspective. And this is titled, Last Predicted Date for End of SEC versus Ripple Lawsuit Approaches. Today is Ashley Prosper's last predicted date for the potential resolution of the multi-year SEC v. Ripple lawsuit. In March, XRP community member Prosper predicted that the SEC v. Ripple lawsuit would end on one of 6 dates. Prosper's predictions include March 23rd, March 31st, April 1st, May 29th, June 5th, and June 21st. With today being the last date, XRP enthusiasts hope Judge Annalisa Torres will issue the much-anticipated summary judgment decision. It remains to be seen whether the case will be resolved before the end of today. Yeah, and so look, I don't mind anybody speculating like this. I think it's fun to have discussion and share thoughts. But, as far as when this is actually going to come down, like I said at the outset, nobody knows except for perhaps Judge Torres, and perhaps even she hasn't decided when it's going to come down. Maybe she is actually still working on some draft of this. Although I would also say, even if that's the case, I still think she knows in a general sense what she's going to do. It's probably more stuff like dotting I's, crossing T's at this point, because presumably she's been working on it for a very, very, very long time. Since the end of last year. But anyway, this piece continues, and there's part of this I wanted to correct, and then I want to talk to you about what might be most reasonable to suspect in terms of an end date moving forward. And so the piece reads as follows. Meanwhile, it is worth noting that other predictions about the lawsuit's potential end date never came to pass. Oh, by the way, in case anybody's curious, at the time I'm recording this, it is 7:23 p.m. Central Standard Time on Wednesday, June 21st. So this would be the last day, as stated by this article, for this individual's suspicions, prediction to come true here. But there were other guesses that didn't come true. Piece continues. As reported earlier, pro-XRP lawyer James K. Filan predicted that Judge Torres could issue the summary judgment decision on March 31st, 2023. However, this forecast did not materialize. And then here's the next part, and this is the part I really wanted to correct. That's not a word. Correct. Another pro-XRP lawyer, John Deaton, predicted the ruling would come before May 6, 2023. That's literally not true. I remember what John Deaton said, and what he was doing was looking at rulings based on specific parameters and points in other cases that Judge Torres had ruled on, including the Daubert motions having to do with expert witnesses, and then seeing, okay, once that comes out, once those types of decisions had come out in previous Judge Torres cases, when did she finally rule on summary judgment? Those were the types of things that Attorney Deaton was looking at. And he said, if this is in line with that, then you'd be looking at having a ruling by May 6th. He didn't predict that would happen. He was just noting that if the judge was operating within the average Judge Torres parameters, then it would have happened. And James K. Filan, he was doing something similar. So, I don't blame them. But it's been interesting, and I want to remind you, in case you guys didn't see this, but I mentioned this last Friday, there were a lot of attorneys anticipating that, at the end of last week, this past Friday, June 16th, that we would have seen the end of the case. In fact, so here's a XRP community member and attorney, Fred Rispoli, and he said on June 16th, hoped Judge Torres' ruling would be out this week now that pleadings were filed. It's past 4 p.m. on the East Coast, and federal court staff usually start packing up and leaving for the weekend around this time. Come on next week. So anticipating there that it would come at the end of the week, and he's not the only one that was thinking along those lines. In fact, there was this tweet from attorney Jeremy Hogan June 16th, and I covered it at the time. But I have something to add to this. So attorney Hogan on June 16th wrote, no ruling in the Ripple v. SEC case this week, but you now have permission to wait with bated breath every Thursday/Friday from now on. So ordered. And I remember covering that at the time and saying, I'm not sure, because attorney Hogan didn't state why in that tweet, why he's saying that we need to be watching for Thursday to Friday. I had some educated guesses that I thought about after the video. And actually, I do think that my educated guess is probably spot on. But I asked attorney Jeremy Hogan this. So this was just a little over an hour ago. This is 6:14 p.m. Central Standard Time, my time zone. And so after all these days, I was just curious again, and especially after all this talk again popping up today about potentially being the end of the SEC v. Ripple lawsuit. It got me thinking about it again. So I sent out this tweet just a little over an hour ago to Hogan, and I said, curious, what do you think makes it more likely that the Torres decision would more likely drop on a Thursday or Friday? Is that just standard procedure for wrapping up a work week or something like that? And I had some guesses, but I just was kind of wait to see what he would say. Now, at the time I'm recording this, he hasn't responded, but again, it's been a little over an hour, so he very well may not have seen that. And also the way Twitter works, like, to be honest with you, I don't see most of the people that tag me and stuff, not because I'm willfully ignoring it. It's because it's an endless torrent of people tagging me and stuff. And so it just flows and flows and flows. I just can't catch everything. And that's with me having however many, I think I have 107,000 people following me. So I get tagged in all sorts of stuff. Attorney Hogan has even more. He has 274,000 followers. So when you have that many people tagging you and stuff, you're going to miss most things. So I don't even know if he's ever going to see what I sent there. And I could send a direct message, but I was hoping to have something public. But anyway, setting that aside, we did get something here, though. Attorney Bill Morgan of the XRP community did see my question, and he responded. Attorney Morgan wrote, weirdly, that is the trend in judgments in my matters in another jurisdiction. Never had one at all delivered on a Monday. So it does seem that, for whatever the reasons are, it does seem to be just standard practice that it's towards the end of the week that rulings of this magnitude ultimately end up getting dropped. And there's an XRP community member who responded to Attorney Morgan. His name is on Twitter is BobXRPcom, and he said, I agree. 33 years in the legal field as a paralegal, and it's more often than not true. And then there was also this from XRP community member V, and he says, I agree with Jeremy. If you look back, most of the decisions in this case have been released on Thursday and then Friday. If I remember correctly, there was one time when a decision was issued during a long weekend too. Yeah, and so I wasn't, throughout the case tracking which day of the week most of these things were dropping. But I do remember what he's talking about. There was one exception at a minimum where something was dropped over a weekend. It might have even been a Sunday. I do remember at the time thinking, okay, that's peculiar. I don't know why that happened, but it did. But it seems to be the perspective for most people that, yeah, it's the end of the week when this tends to happen, which leads to the speculation. So, given that it is Wednesday, the 21st at the time that I'm recording this, and given that it's past typical business hours, fine, the ruling could drop anytime. Not likely to happen this evening, but tomorrow's Thursday. So if Thursday and Friday are the days that it'll be most likely for this to happen, we're about there yet again. So just watch, as Attorney Hogan suggests here, with bated breath every Thursday and Friday. So I'm going to be scrambling for my phone when I wake up on Thursday and Friday and see if the news has dropped. And it's just so funny because, you can check the news. You can hop on social media to find out. You could hop on, you could probably go to mainstream news publications. Honestly, they cover something that big pretty quickly, I would assume, but certainly crypto media. But another way to find out, frankly, is if you just look, you go to like Live Coin Watch. Is XRP up dramatically or down dramatically? If the answer is yes to one of those, then probably the news dropped. If it's way, way, way up or way, way, way down, depending on whether it's good or bad news, might mean that the news dropped. So one day we're just going to wake up and that's what we're going to see. I'll probably just hop on Twitter first, honestly. I'll probably just do that. Because as soon as it drops, the news is going to spread quickest on Twitter. In fact, I'd count on that to be circulated on Twitter more quickly and more well-known on Twitter than I would on your typical crypto media outlets or pretty much anything else. But markets will respond very quickly. I'm very confident in that. And here's a tweet from attorney John Deaton, and I like this one. He said, because obviously markets have been rallying, I'm not going to talk about that in this video too much, but attorney Deaton mentioned this along with something else that I thought was a little fun, so I thought I'd throw it in the video here. But it is nice to see Bitcoin, it's leading the pack, up over $30,000, down from just the other day, it was at 24,000 and something, now back up quickly over $30,000. And look, crypto happens fast. It's happened quickly in terms of price action for XRP too. But who deserves positive price action more than us? And so great to see Bitcoin leading the charge. It's fine. Bitcoin has always led markets. But here's what attorney Deaton had to say. With Bitcoin up 10% and climbing, it would be nice for a great decision to come out this week being a significant win for all crypto. But a certain group of token holders who have held on to a specific token through incredible FUD campaigns, as well as being attacked by the SEC, deserve it most. Well, I don't ever want to put words in attorney Deaton's mouth, but I'm going to go ahead and speculate he's talking about XRP and the XRP community. I'll just hazard a guess right there. And so can you imagine, this would be an amazing time to think about this, with how the markets right now have been blasting off with Bitcoin leading the way. Can you imagine if we wake up tomorrow and we actually do have that positive news, say it finally comes, and Judge Torres, and it's over? That in conjunction with an already positive movement in terms of market activity goes together like spaghetti and meatball. But then there was this. There was somebody that tweeted, it's caught the attention here of former SEC attorney Mark Fegel, and the person that tweeted said something along the lines of, Ripple could have been selling weasels, that's the example that they gave, because it could literally sell a live animal. Like, that's literally a thing that could happen, not that they're going to. But whether they're selling that or cryptocurrency, the point is that they're making is it doesn't matter what the asset is. Now, attorney Mark Fegel, I do get the sense he's operating in good faith, but I think he is way, way, way off base on what he stated here. And I know he's the lawyer, I'm not. But there's no shortage of lawyers that would agree with me. And so what I've done is I just take this how I approach everything in life. I just want to listen to two well-informed competing sides. I want them to argue intensely, and then I can see for myself who I think is making the best argument. That's how you come to conclusions in life as a human. If you're an adult, that's what you do. And so attorney Fegel here does seem to believe that it's the asset that is the security. Like, and maybe he wouldn't word it like that, but if you look at what he's arguing here, he might as well be arguing that. That's what I'd say. And so attorney Fegel responded to this individual and said, Ripple raised $1.5 billion selling XRP to the investing public, but not a Ripple product? It's not a Ripple product? If secondary market players like exchanges want to argue it's no longer a Ripple product, it is more like a weasel. Great analogy for the inherent quality of crypto, by the way. They can give it a shot. Okay, so he seems not to be that big of a fan of crypto just in general anyway here. But he's arguing, he's literally arguing, it's on your screen, that XRP, upon launch, was a product of Ripple. And so I read that, and I just, nothing against this guy on a personal level, but I just kind of roll my eyes. I was like, do you even crypto bro? And I think the answer is no. He does not crypto bro. I don't think he cryptos. And attorney Bill Morgan caught that and responded with the exact perfect answer. He said, You have really understood little about XRP itself or the nature of the XRP ledger if you think XRP is a product of Ripple. As to inherent quality or value, people every day are making cheap, fast cross-border payments using XRP. Utility means something, has value to the user. Yeah, and so that's obviously spot on. But doesn't this sound like what the SEC is actively arguing? Doesn't it sound strikingly similar to like the embodiment theory? You know, the embodiment theory, because all the activities surrounding the XRP ecosystem, that's effectively what the SEC is arguing. That's the embodiment of those promises, efforts from Ripple. That's the crap argument that they put forth here. And here you have Attorney Fegel arguing, it's on your screen, that XRP upon launch is a Ripple product. And now you can just argue that it's not if you want secondary market transactions to not be stuck in that web. What? It's a decentralized cryptocurrency. What are you talking about? And so, and this is why, like, those, if you go like to the Hinman test, you know, it's just Hinman's personal opinion, and you know, you talk about you know, the decentralization test, which technically isn't part of Howey, but it does play into whether or not there may or may not be a common enterprise here. Well, this goes back to my question, proving the point that there's not sufficient regulatory clarity. Because if you have to argue that other people end up using XRP for other things beyond what Ripple was initially using it for, well, what does that even mean? That's not part of the Howey test, even technically. So again, it plays into like the common enterprise aspect a little bit, but there's not clarity there even. So how many people are entities have to be using an asset for various things for Attorney Fegel to not make this nonsense point about XRP originally being a product of Ripple? Because it's literally not true. It's just unquestionably literally not true. It's like, I mean, what if it was a living creature though? So what if Ripple were the first company to use a living creature for a purpose, and no humans had ever used this particular living creature, hypothetical creature, for any purpose at any point, at any time in history? So if Ripple's the first to use the creature, then is that a product of Ripple? Because we're talking about an underlying asset here. Do you see how stupid that is, though? And then what? If other people start using this hypothetical animal that up to this point no people had ever used for any purpose and not even eating it, then what? Then it's just, if more people use it, then it's suddenly, what? A decentralized animal? Like, what is it? It's so stupid. You see how quickly this stuff falls apart. And so then we had this guy that I blocked because I just don't think that he's intellectually honest. He goes by the name Scam Detective. And he responded to Attorney Morgan. He said, but Ripple did in fact create XRP, which is obviously literally not true. And this is where David Schwartz jumped in and he said, I really don't understand why people keep repeating this. It's been explained dozens of times. The company that became Ripple didn't exist prior to September 2012. The asset that became XRP was created in June 2012. And so there you go. It's literally not true. If you want to make an argument that some people associated with the creation of XRP ended up being either co-founders or early on associated with Ripple, then you can factually state that. I have no qualms with that. But don't state that Ripple created, because it's just factually not correct. It's literally not true, provably not an untrue statement. Because David Schwartz, mind you, for example, one of the three people that created XRP in the XRP ledger, he didn't get any XRP for free. He literally didn't. And he's not a founder of Ripple. So he's one of the creators that's not a founder of Ripple. So to make this bogus claim that Ripple created, it's just when people operate in bad faith, and that's why I ended up having to block this guy. I mean, I don't care if people disagree with me, but you know, there comes a point where if you just keep lying and you're not operating in good faith, eventually I don't want that in my life. You know, I have no problem with people just disagreeing, but if you lie, if there's lie after lie after lie after lie after lie, and I can just see the degree of disingenuousness, no, I'm just not interested. So anyway, though, Attorney Fegel responded to Schwartz and said, which is fine for historical purposes, but irrelevant under securities law. Ripple is the seller of the security for registration purposes. It doesn't matter if they're not the legal entity that created the token. And you know what? Fair enough on that point. That is true. You can sell something as a security even if you didn't create it, whether you did or didn't create that asset. That is true. But then you go back to, one talks about something that's irrelevant. It's what Attorney Fegel just set up here. You know, if secondary market players like exchanges want to argue it's no longer a Ripple product, no, that's an incoherent sentence. So that sentence is irrelevant. That's perhaps the most irrelevant thing I've covered in this video so far. And David Schwartz responded, though, if it's irrelevant and doesn't matter, why do so many people insist on lying about it? Well, I'll hazard a guess there, narrative purposes, and not that we can get the hearts and minds of all these people, but you can just see, like it's the case with the scam detective guy, which I ultimately blocked after having him muted for a long time. It's just what you note is that they have this idea in their mind, and you don't know why, but you can observe it's the case. Here's the end goal. Here's what I want people to believe, and then you argue everything, whether it's factual or you know it's not true. You just argue everything to try and persuade people to get to that end goal. And different people can have different reasons for that. They can be Bitcoin maximalists. They got heavy Bitcoin bags. They want every other coin to fail. Yeah, maximalism could be a part of it. With the scam detective guy, I don't know. I don't know. I'm just observing that this is the case. This is how these people are behaving. And it's complete and utter nonsense. And then there's also this from Attorney Deaton. And this was part of a thread that I covered in completion, so I'm not going to get in this video. But part of a thread that I covered in a recent video from Attorney Deaton reads as follows. The Aquasonic case, judge said Howey was to be applied at the time of the transaction. Attorney Lewis Cohen did an exhaustive study on federal appellate case law and found no case to support the underlying asset being the security. So I wanted to touch on this because, again, with the nonsense that came from Attorney Fegel, nothing against him on a personal level. I think that he's saying stuff he believes. I just think he's disastrously wrong on that one point that I just cited in particular. I just don't find it persuasive. It's outside of law, and here are other attorneys that have persuaded me to believe that. Attorney Deaton and Lewis Cohen. And Lewis Cohen, by the way, he's the one that wrote, I can't remember the full name of this paper. I think it was like almost 200 pages submitted to Judge Torres, just exhaustively going back, all the case law going back like 76 years, whatever it was at the time. It was something like the ineluctable modality of something, so on and so forth. I can't remember the whole title, but it was incredible. It's just like, here you go, Judge Torres, did all the homework. What the SEC is arguing doesn't make any sense. There is no precedent for it. There you go. And just handed it, the whole thing, in-depth analysis. I can only imagine the amount of time that it took for Attorney Cohen to put that together. And that was submitted by Attorney John Deaton as an exhibit, by the way, in his amicus brief. Just a complete baller-ass move as far as I'm concerned. But anyway, so Attorney Deaton here was citing a separate case, the Aquasonic case, and talking about secondary market transactions. And Attorney Cohen retweeted that and said, indeed, John Deaton. Another case I like is Hogan versus Dubois rehearing, where the full Ninth Circuit concluded that a secondary sale of an asset was not automatically a securities transaction merely because of promises made by a third party. You need to look at the facts at the time of the transaction. Right? So if you just have to look at the facts at the time of the transaction, then why do we need to argue whether XRP is by nature a product of Ripple? Why do we have to? We don't have to do that. You see that? That's the point. That's why I'm highlighting this. Attorney Fegel is incorrect on that. I know he's the attorney and I'm not, but it doesn't make sense. And Attorney John Deaton expanded upon that. He retweeted that from Attorney Cohen, and he used a term that I was not familiar with. So since I have the sum of all human knowledge at my fingertips with interwebs, I Googled it. It's called in-bank panel. And so I found the definition description of this on Cornell Law School's website. It's in-bank, E-N space B-A-N-C. In-bank is French for on the bench. The term refers to a special procedure where all judges of a particular court hear a case. When the court believes that the matters are especially complex or important, the in-bank procedure will be used. And now we know, and knowledge is power. So here's what Attorney Deaton had to say in response to what Attorney Cohen said. Lewis, I now remember this case from your research article. Thank you for reminding me about it once again. In the Ninth Circuit, nonetheless, with an in-bank panel, all 11 judges, it was held that just because the first sale satisfied the Howey test did not make the subsequent secondary sale of the condo also an investment contract. With an investment contract, the underlying asset, even written contracts like in Howey or in Telegram, are not the securities. So again, so pause. If that's the case, why this comment, Attorney Fegel, about having to argue or exchanges arguing that XRP is no longer a product of Ripple, as though there was a point in time where it was just a product of Ripple. It was never just a product of Ripple. And that, so by arguing that, it just proves that you don't understand the nature of decentralized technology, which is why I'm pushing back against this stuff. And then Attorney Deaton says, Howey must be applied at the time of each sale. When you take Howey and all the cases in totality, secondary sales are not securities. They could be, he writes here, they could be if the circumstances surrounding the sale also satisfy Howey. Okay, so pause. That is true, and I've pointed this out before, so you could say, okay, there's some instances where secondary market transactions could be securities, but now we're getting into the weeds and nuance is required to understand that. Just make a blatant, that's why I don't want to make a blatant statement quite like that. Not that he is, but a secondary market transaction could be completely unrelated, but could still be an investment contract for different reasons having to do with different parties. So it could be so it could satisfy the Howey test for reasons completely unrelated to the initial transaction satisfying the Howey test. That's the point. And then Attorney Deaton says, but there isn't a single case in history where an investment contract was found and there existed no privity between the buyer and promoter / issuer. Hard stop. Exactly. So there's always some sort of legal arrangement. There was always privity. And never an instance without that. Hard stop. So there we are. So covered a couple different topics. It's fun to intellectually think through all this stuff, especially, like, I just, again, like I said a little bit earlier, I really appreciate the attorneys, because they're the ones that spent years and years, getting to the point where they could even have this profession, and the amount of effort and work and knowledge, it's impressive. It is. And so I love to see people of that caliber argue and debate, well, more so debate against one another, sharing ideas. And because that helps people like me and the rest of you all come to a conclusion, because it's just the case. I mentioned this recently. It's just, we're not going to be experts in life in most things. We need people who are experts to debate one another so that we can just come to our own conclusions in life, because we deserve to and should have opinions on a whole host of things on various topics in life, but we're never going to be experts in all those things. We don't have the time or even necessarily the interest to get into that level. That's why I appreciate people that have expertise in a whole host of different types of things. And so it's nice seeing this here, because without this type of stuff happening, I'd just be lost in the woods effectively. When it comes to all this stuff, I'd be as concerned as I was after the SEC v. Ripple lawsuit dropped, because part of what made it most scary for most people, and I think that I include myself in this camp. It's just right after the lawsuit dropped, the not knowing, not having an understanding of the implications, what that meant. Who's right, who's wrong? I mean, I thought that it was nonsense from the SEC's part from the beginning for various reasons I even articulated back then, but I was still at the beginning of my journey of understanding exactly the degree to which the SEC was way off base and a disgusting, horrendous organization. So, anyway, all that to say, I just appreciate the back and forth here, and it's fun to think through all this stuff anyway. And also fun to speculate a little bit about the end of the lawsuit. So are we going to wake up tomorrow or Friday and see it's all finally over? No freaking clue, but I hope so, and it's possible. It's even if it's not this Thursday or Friday, I'm just gonna be looking. Okay, next week, Thursday, Friday. All right, come on. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.